Good morning, everyone. Welcome to Estate Planning Lunch and Learn. This is Lisa Grennan with MWR, and really appreciate you joining us this morning. We are so excited to welcome Stacey Lott. She's an attorney practicing in elder law and probate and estate planning. Stacey graduated from Michigan State University and Cooley Law School. She has been practicing for many years in Battle Creek, and she resides in Battle Creek with her husband and 2 children. Thank you, Stacey, so much for joining us, and welcome this morning.
Thank you, Lisa. Are you guys ready for me? I don't like doing, obviously, webinars. I don't think anybody likes it. And those of you who have seen me in person before, I think we all do better when we could be in front of you. And generally, when I do a presentation like this, and I'm sure that some of you have been at my previous ones, I try to leave time in the middle of the presentation as I'm going along for you to ask questions live. However, we have a feeling that there's going to be more questions now that people can type out and send to me. So I think this time what I'm going to do is go through the presentation, and then at the end, if there are questions that I didn't answer, we can go through those at that time, if that's okay with you. All right, so the very beginning, we start off with what I'd like to talk about is the frequently asked questions in estate planning and elder law. These are the questions that I get asked the most on a daily basis, a weekly basis in my practice. So these are the ones that are the best ones for me to talk about when we're here. So we'll go to the next slide, and maybe we won't. Oh, sorry, I gotta go back. The very first question I think that people ask me the most is, what is probate? Probate seems like a scary thing because there are a lot of seminars that people put on where they invite you in for a chicken dinner and they tell you that probate is awful and the government's going to come after you, all of your assets, and you're going to have to pay a lot of taxes and all of this stuff if you don't buy this big trust booklet right now for thousands of dollars, and people get really scared. They prey on your naivete, I guess, about what probate is, and they make it out to be a lot worse than it is. However, if we can avoid probate, of course, we're going to try to do that. That's why you hire an attorney, is to help you not have to pay extra or your family have to pay extra after you're gone. But probate in general is a court proceeding. And what happens is the court then, you'll appoint the estate will have somebody that's in charge of the estate. It's called the personal representative. It used to be called an executor. The court will appoint that person, and then that person will be allowed to distribute your assets out to whoever your family is. If you have a will will tell the court how the personal representative is supposed to distribute that stuff. If you don't have a will, it goes to your next of kin, okay? And then the state has its own, priorities and next of kin and who gets what. So the problem is a lot of people think, or a lot of attorneys kind of lead people to believe that if you have a will, if you've gotten a will written up, that you don't have to go to court, that your family won't have to do probate. And that's just not true. Probate, it's not, like I said, it's not as big a deal as people make it out to be, but it's something that we really do try to avoid. So the things about probate are that you have to pay an attorney to do the probate process for you. I'd say around here, you're looking anywhere between $3,000 and $5,000 for a probate, to be opened by an attorney in Calhoun County. You have to pay fees to the court to open the probate. You have to pay fees for any item that goes through probate. It's called inventory fees. And those things, are things that you wouldn't have to do if you did some other planning up front. The other thing about probate that some people don't like is that it's public record. So when there's a probate proceeding, anybody can go into the courthouse and ask to see the probate file and see everything about your life and who you're giving what to and what you're doing. So the other thing that we do in probate is that we appoint guardians or conservators for minor children. So that is a probate proceeding that has to happen if you pass away and you have minor children. So, but that's something that's pretty, swift. It's just, let's get the conservator or guardian appointed for this person. But it's important to know that probate maybe isn't as bad as you think it is, but if there's ways to avoid it, we always would try to do that. Okay, don't let people scare you into buying these huge trust packages worth, like I said, that cost thousands and thousands of dollars. Don't let them use scare tactics to help you avoid probate. Okay, because there's other ways to do it that, with local attorneys that might be better. Okay, let's go to the next slide, because we talk about the difference between a will and a trust, and that really kind of ties in with the probate. For instance, let's talk about what a will is. A will, once again, is where a personal representative is in charge of distributing your assets, just like I said. So if there is a probate proceeding going on, your will tell the court, I want this person to be in charge, and I want this person to give it to these people. Then you also can nominate the guardian and conservator in your will. We said that as well. That's where you would nominate who you want to be in charge of, maybe who you would want your children to live with if you have minor children, or who you would want your take care of your children's money. That's the conservator. A will is subject to the probate process, which I just talked about with you, and it becomes open for public record, like we talked about. So a will basically will allow you to do everything that you need to do. It's just that it does have to go through the probate process, and it might be a little more expensive to your family after you're gone. Now, some people think, I don't care, I want to pay less now and let my family deal with it later. And that's fine. And most people say, I want to make this as easy on my family as I can after I'm gone. So maybe a will isn't the best thing, for me right now. So then the next slide is trust. Hopefully it will pull up here. Trust. Trusts are documents. They're actually contracts, but they're documents that basically say, so it's the Stacey Lott Trust. Stacey, I'm married to my husband, Kyle. So it's the Kyle and Stacey Lott Trust. And the trust says how you want everything to go and who you want to be the trustee after you're gone. However, what happens is we actually title our assets into the name of the trust. So we do a quitclaim deed that puts the house into the trust, or we do we go to the bank and we make the trust the owner of our account. So on paper, all of our different assets are titled into the trust, or the trust is the beneficiary of, say, our life insurance policy, things like that. The reason that we have done a trust is because not only do we want to avoid probate, because what happens is if we're both gone, the trust owns the assets. So the successor trustee can just jump in, get those assets, take care of our children with them, that kind of thing. If we didn't have a trust and we pass away, and our assets have to go through probate, that the reason we have to do that is because they have to get out of our names and into our children's names. And the way to do that is to, like I said, go through the probate process if you don't have a trust. The beauty of having a trust, especially if you have minor children, is that you can pick at which ages they get their money. So I know I have a huge life insurance policy, and I'm probably worth a lot more dead than I am alive. So if something happened to me and my husband, I have $1 million policy. I don't want my 17-year-old twins ending up with, $500,000 each when they turn 18 in 6 months. And that's what would happen if I didn't spell out in the trust when they would get it. So what happens is the trustee that we've picked to help my children and take care of their money would be able to use that money for their health, their education, their maintenance, their support. So if they needed a car to get back and forth to KCC, or if they needed money for their books at school, or if they needed a surgery that their insurance didn't cover, the trustee in their discretion could use that money for them. But if my son says, yeah, I need a new car to go to school, I want this brand new Mustang, they can say, no, but we'll buy you this nice new, nice used Toyota or whatever to get you around. So you can give your trustee discretion to do the right thing until they're old enough to be able to handle money. So a lot of parents say things like, okay, they get a third at 25, they get a third at 30, they get a third at 35. That way we spread it out, and if they make a mistake when they're 25, they get another shot, that kind of thing. So minor children is a really good reason to use the trust. Because if you have babies, I mean, my kids are going to be 18 soon, but when they were babies, we know that any of our assets will be put in this trust to help, raise them so that they have a good quality of life. The other reason some people use trusts is if they have a taxable estate. That is not such a big deal anymore, because now in 2021, you have to have $11.7 million per person. So we're talking $23 million per couple to even worry about having a taxable estate. I can tell you, I might have one or two people that are in that situation, but other than that, most people don't have to worry about that anymore. Another reason people do it is because they might be in a second marriage and they want to make sure that if something happens to them, yes, maybe things can go to their spouse, but maybe some things can go to their children too. Because if they don't do anything, there's a chance everything would go to their spouse and their children might be left out. I've had situations where it's a second marriage. They agree that if something happens to one of them, everything would go to the other. And then after they're both gone, things would be split equally amongst all their kids. But then the second spouse decides, you know what, I don't ever see his kids or her kids, and I don't want them to have anything, so I'm just going to change it and leave everything to my kids. And even though, maybe most of the money came from the deceased spouse. So there are ways to protect assets for your children if you're in a second marriage or a third marriage or a fourth marriage. And we do that a lot. There are also reasons to do trust if you cohabitate with your partner, but you don't get married. And I have a lot of clients like that. But they want to make sure that the partner is taken care of should something happen to them. But they don't really want them to be joint on their assets right now. So there are ways that we can do trust to make sure that a partner is taken care of, because they are not next of kin and they wouldn't automatically be able to get stuff. So I'm seeing questions here. And once again, we're going to wait till the end to answer some of these, but they're good questions. And I guess I can kind of mention it now. Most married couples do joint trusts. Because unless they have the $11.7 million, there's no reason to do separate trusts. However, if it's a second marriage, like we talked about, or we're trying to protect other people or make sure they get assets, we do separate trusts. We also do single trusts or separate trusts when we're doing some elder law planning. So for instance, if someone comes to see me, if a couple comes to see me and one of them has been diagnosed with dementia, or maybe not even dementia, Parkinson's, or have had a stroke, but they're still competent and they know that they're going to need care in the future, then we might put all the assets in the healthy spouse's name in their trust. And their trust might say, upon my death, everything goes to my kids instead of my spouse, so that if the spouse needs care, they can have the care because they don't have any assets in their name. And that works. So there's a lot of reasons that we might do a separate trust rather than a joint trust. Some people will have a trust, like maybe they inherited something from their family and they want to keep it, kind of in their name and pass it down to their kids, even if their kids are their spouse's kids. And we might have a separate trust for that one person, for that one asset, maybe a big family farm in another state or something like that. But we still have the joint trust for everything else. So it really depends on what the assets are, where they want them to go, how they want things to happen, what kind of trust we would do. So it's not a one size fits all thing, but they are great documents. I kind of call them reaching up from the grave after you're gone and controlling things, because you can write out now what you would really want to happen and make sure it does happen by having the trust in place. Okay, so I think that covers wills and trusts right now. But once again, if you have questions, we can get to them at the end and talk about it. The next slide is, what is a living will? And it's coming up, I think, here. This is a really good question, because many people think that automatically, if you're married, that your husband or your wife can go into the doctor's office and make any medical decisions for you if they need to be done. And that's not true. In certain emergent situations, they can do it. But let's say that you're, in a coma, on life support and it's time to pull the plug and we don't have a document that says that they can do it, they might have to go to court to become their spouse's guardian in order to be able to make those decisions. Also, to get medical information. If something happened to me and I was, in an accident in the hospital and my husband wanted to find out what was going on, they are really not supposed to tell him anything. They do not. So if he has a document that says, hey, I am her patient advocate, I need to know, there's a HIPAA release in here, then they can tell him things. So a living will is something that happens in other states, but people always call them living wills here. A living will is basically a healthcare power of attorney or a patient advocate designation. That's what we call them in Michigan. So in other states, living wills kind of write out what you would want to happen if you were unable to make your own medical decision, like pull the plug or leave me on life support or, get rid of feeding tubes, but you can keep me hydrated or those kind of things. So for instance, in Florida, you can write all that out. And then if that happens, the doctor has to follow what you've written out. In Michigan, we don't do that. In Michigan, we pick a person to stand in our shoes and make a medical decision if two doctors certify that we can no longer make our own decisions. So I always tell people, please, please, please make sure that you pick the person who would be willing to do this for you. And I'll give you personal stories, and I'm sure some of you who've heard me before have heard this story from me, but when my dad passed away years ago, 24 years ago, and when my mom was doing all of this, 10, 15 years ago, to me, it was so overwhelming to think about not having her that I didn't think I could be the person that was listed on these documents. So I had my sister do it, and I was like, I don't want to do this. I don't want to be the person on this. But then as she's gotten older and she's had some significant health issues, I'm the one with the more flexible schedule, and I'm the one that ends up taking her to the doctor's office most of the time and, doing things with her and helping her make decisions. And now it's like, my sister's like, you should be the one listed first on this because I can't get there. She's a special ed teacher in Ann Arbor and she can't be, with my mom as often. So as she's gotten older, maybe I'm the person to be on that. So it really can change, and it depends on what your kids are willing to do. When I was younger, there was no way I was going to be the person to make that decision. But now that I've gotten older, I think I could do that for her because I want to help her, right? So not that I didn't want to help her before, but I understand how when you're really sick, things can be different. So make sure you pick the right person. I'm going to give you another scenario that you've probably heard before. Like I said, when I first started my own practice here in Battle Creek, I had a client from Florida the client's daughter call and say, my dad is in the hospital in Marshall. He needs a blood transfusion. My sister is listed first on the patient advocate. She's a Jehovah's Witness, and she refuses to give him a blood transfusion. And I'm in Florida, and she's a nurse in Florida. What can I do? So what ended up happening is the sister resigned. The daughter got on the phone with the hospital, told them everything, that she needed to do to get her dad the blood transfusion, flew up here. The dad was in the hospital for a few more days, and the daughter from Florida stayed, and she rolled him in my office in a wheelchair like 4 days later to sign a new patient advocate form, taking the Jehovah's Witness sister off because the dad was not a Jehovah's Witness, and he would have wanted to have a blood transfusion, and he was just thinking, well, this daughter is closer, so I should pick her. So please make sure that you're picking the person that would make the right medical decision for you, because some people won't, do what you want. So that's important. Also, another important thing is making sure that if you have children who are turning 18, like my kids are in July, that you do patient advocate forms for them, because if they're off at college and they have a medical emergency, they can't tell you anything. When they're legal adults, you can't get their medical information until they sign a form that allows you to do that. So it's important if you have young children that are over 18 that you also get patient advocate forms filled out for them. I think that covers everything as far as patient advocates go. The next one, let me go to the next one. Ta-da. This might be the biggest question I get asked, to be honest. And the question is, if I go into a nursing home, will I lose my house or will I lose my other assets? It's scary. They're saying that people that make it to age of 85, that 85 and older is the fastest growing segment of our population, that 80% of people that reach the age of 80 are going to need some type of long-term care. And so as a result, this is something that I think a lot of people are worried about in the future, or people are worried about for their parents. And it's a good question. So I guess the short answer is no. If you get good advice from an elder law attorney or somebody that knows about the Medicaid rules. I'm going to go into estate recovery, the next slide right now. No, let me go back. Because if you're allowed to have a house and the house is exempt, you're allowed to have a car, you're allowed to have, if you're single, $2,000 in the bank, you're allowed to have a prepaid funeral. But the point is, if you have your house, how are we going to protect it to make sure that after you're gone, the state can't come back after it? And that's the next slide. The next slide is estate recovery. So if the state pays for your care and anything that you own ends up going through probate, the state can come back after those assets to get paid back for the care that they provided for you. That's estate recovery. Even though your house is exempt while you're alive, and the point of that is, let's say you go into the nursing home for rehab because you broke your hip. And the whole goal is, let's get you strong enough so that you can come home, but maybe it's taking longer, so you have to apply for Medicaid so you can stay there for a year. But we really want to get you home at some point in time. That's why they let you keep the house, so that if you ever need to go home, it's there. I think, we really want to keep everyone as independent as they can be for as long as they can be. However, if you pass away and you own this home and you've been on Medicaid before, then the state can come back after the house if it goes through probate. So we do things to protect that house, to make sure that the state can't come back after it and that it doesn't go through probate. That does not include putting it in a trust, because unfortunately, when you go on Medicaid, any house that's owned by a trust counts as an asset. If it's owned by you, it doesn't count as an asset. So we do these things called ladybird deeds. And ladybird deeds are deeds that say, I own my house for my lifetime. I can sell it, I can mortgage it, I can lease it, I can do whatever I want. But then upon my death, it goes to my children or wherever I want it to go. Those ladybird deeds are kind of the holy grail of protecting houses if someone needs Medicaid, because they make sure that you own your house for your lifetime, but then upon your death, they transfer directly to your children and who you want it to go to, and it doesn't go through probate, so the state can't recover against it. So estate recovery is kind of a big deal. It's tricky with cars. Often I'll tell people, if it's a single person that's going in the nursing home on Medicaid, sell the car and we'll figure out what to do with the money, maybe buy a prepaid funeral or something, because cars don't have a deed, and titles, you can't add someone to your title because that's considered a gift. So there's just other ways to kind of try to get around things. But estate recovery is a real thing, and that's the thing I think that scares people the most. If I go into the nursing home, they're going to steal my house. They're going to take my house from my family, and we're going to make sure that that doesn't happen. If you go to see somebody who understands elder law, which is my next slide. Make sure that when you're getting advice from people, talk to someone who understands elder law, who practices in the area of elder law. Elder law is a specific type of law that has to do with disability planning. It has to do with, how do I protect assets if I end up going into a nursing home? And there are so many different attorneys out there that can give you advice. I have attorneys that give advice that was correct 20 years ago, and the rules have changed so much. Or I'll have a CPA tell someone, you know what, you can give away $10,000 to each of your kids, and that's no problem. That doesn't count against you when you go to the nursing home. Well, it's 15-something thousand now, and IRS rules and Medicaid rules are completely different. So you can't give $500 to your kid if you're going to go into the nursing home. in the next 5 years because there's a 5-year look back. So you'll get advice from your neighbor, from someone at the diner when we can go back to diners, from your attorney who doesn't know anything about Medicaid, from your accountant, from your financial advisor. And I think everyone means well, but I would really be careful about who you talk to. And locally, I mean, you know who people are around here, but let's say your mom or your dad is in a different state and you don't know how to get advice about that state's laws. What I would recommend is going to a local nursing home in the county where they live and asking them, who are the good attorneys around here who know how to do elder law, who know how to get people eligible for benefits, for Medicaid. And they are really good about giving you the right advice because they know who does it for their residents and how they get paid for Medicaid and which attorneys help that happen. So I always recommend that if you're not sure, make sure that you talk to the local nursing homes or assisted living facilities because they will know. All right, let me go to the next slide. This is a good one. This is one, it's not a question really, it's just something that people always tell me, well, I'm gonna do this because my mom did this, or my dad did this, or my grandma did this, and it worked just fine. Can I just make my kids co-owners of my house or my other assets? And my answer is a resounding no. And the reason is, let's go to the next slide, is once again, in the very beginning, it says in most cases, that is not a good idea. First of all, your kids will have, if you add your kids to your house or your investments or whatever, they can have control over your asset. So let's say you have a house and then you have a cottage on a lake somewhere. And as you get older, you're thinking, you know what, I just can't keep this cottage up anymore. I want to sell it. I could use the money. I just want to get rid of it. But my daughters are on this cottage with me and I got to get them to sign off so I can sell it. And one of the daughters is like, no way, we're expecting to get that as our inheritance. And I think that, you can't sell this. This is such a good investment, Mom. It'd be better for you to sell your house, keep the cottage, and just gives you all their advice about why, you shouldn't be selling it and thinks they know more than you do. You can't sell that house without them signing off because you added them to the deed. So that's the first reason why I don't like having your kids on your assets. Another is it can be a liability issue. So let's say that your child gets in a car accident and hurts somebody and they get sued and they have a judgment against them. Well, they own your house. They can put a lien on your house to satisfy the judgment of your child. Or if they get creditor issues and creditors come after them, they can put a lien on your house. Or if it's an account, I had, and I know I've told you guys this story too, and those of you who've heard me before, bear with me, but I had a client who had had both of his daughters on his money market account at Kellogg Credit Union. He had $70,000 in there, and his daughter went through this horrible divorce. Her husband, had an affair, and she was so mad that she just kept fighting things and bringing things up in court. And the judge had enough, and he ordered her to pay the husband's attorney's fees, and she didn't because she didn't have the money. So they put a judgment against her, and they sucked $40,000 out of the dad's account because her name was on the account. That happened. And he was just devastated. He felt horrible. She was devastated because she never thought that having her name on her dad's account would, make his money disappear. So, I mean, just things that you'd never expect to happen, and you don't know what creditors are going to pop out of the woodwork. Just don't do it. Another thing, potential tax consequences, that's not such a big deal anymore because now you can pass your house on to your children without uncapping the property taxes. The 5-year look back period is a big deal. So that is what I talked about earlier, about if you give anything away within 5 years of having to go to a nursing home, the penalty for giving that asset away is to pay the same amount to the nursing home. So if you give away a $100,000 house to your kids and you have to go in the nursing home in 3 years, then you have to pay $100,000 to the nursing home before you can get on Medicaid. And I don't think many people have that kind of money. And then if you can't, and we have to get the house back into your name to try to figure out if we can sell it or do something to, kind of remedy the situation, you have to hope that your kids are willing to sign off on it. And if you add your kids to your deed, that's a gift of part of your house. So it's not just the entire house you're giving away. Maybe you're holding on to part of it. If if my mom added me onto her deed for her cottage, then I own 50% of the cottage, and she gave me a gift of 50% of that cottage. So I'd have to be a nice person, sign off on it, and give it back to her. But if I wasn't a nice person, then that's happened in my practice too, that people refuse to sign off because they think it's theirs. So the joint assets also can go to the survivor. So that means, let's say you have 4 kids, you add one of your kids on as the, on your bank account because you want them to be able to sign checks and do things for you. And then that one kid inherits the account after you're gone, but decides, you know what, I did almost everything for mom. I don't need to split this up with my brothers and sisters. That happens, and it happens all the time, and mom never expects it. And then she passes away, and these kids, the brothers and sisters, are like, are you kidding me? You're going to keep the, $80,000 bank account because you think you did the most for mom? And the truth is, legally, she can keep it. So that's another reason why you don't just want to add, children onto your accounts. So the way to avoid all of this, basically, is to have a really good, durable power of attorney that allows people to sign, checks for you or access your bank account if you need them to. If you're not able to handle it yourself, without them being owners of your account. You can also do a trust or a ladybird deed that gets your house, to the people you want it to go to, without having it go through probate, without adding them to the deed on your house. So that's why I don't really like to do joint assets. It's kind of a big deal, but I think that gets me through all of my slides in just about a half an hour, which gives us time for questions. So let me go over here because there are some. Let me go to my next slide. Here we go. All right. Let's see. Okay, so these are great questions. All right, let me start with the first one. It says, do wife and husband need to set up separate individual trusts, or could it be, hold on, a joint trust? Any benefits of either? So I think I talked about that as I was going along because that question popped up. So there are benefits to having joint trusts. There are benefits to having separate trusts. It really just depends on the scenario. And I know I talked about that before. And then the same person asked, can one have both a trust and a will? If so, what governs, the will or the trust? That's a great question, and I should have brought that up sooner. When you have a trust, you still have to have a will. It's called a pour over will, like you're pouring a pitcher. It basically says, your will says everything goes to my trust. And the reason we do that will is if, let's say, I have everything in my trust, my husband and I do, and then we find this piece of land in Tennessee that we want to buy in the mountains, and it's really cheap and we can get it quickly. So we decide, are you there, Lisa?
Yeah.
Were you talking to me?
Yeah, I'm here.
Did you ask me a question?
No.
Okay, I thought I heard you. I'm sorry. Okay. So if we decided to buy this land in Tennessee and we get it, and then we forget to put it into our trust, and so this one piece of land in Tennessee has to go through probate after the second of us dies, but we want to make sure that piece of land or goes into the trust to be distributed the way the trust says. Well, the will is going to say that. The will is going to tell the probate court to put that property into the trust to be distributed the way the trust says. So that's why we have to have that pour over will. We also have to have the pour over will when we have a trust, because that's where we appoint who's going to be the guardian and conservator of our minor children. So I think the trust is the controlling document because that is allowed to distribute the assets, and you have the person that's in charge of everything. The will only comes into play if something has to go through probate, okay? Or if you have minor children that need to have a guardian or a conservator appointed. So I hope that answered that question. Let me go back up. Are you liable if you are on your parents' account and they get sued? No, you're not liable. They can't come after your assets if you're on their account. But they can come after their assets if you get sued and you're on their account. So they can take that. So Just because you're on someone's account doesn't mean that you're going to get sued as long as they're not on your account. So if your parents aren't on your account, you're not liable. Next question, 2 questions. 1, if you still owe on your home and on a ladybird deed, can it be stipulated to continue to make payments from your existing funds without changing owner on title? Change the owner to someone else when they reach a specific age in the future. That's a tricky one. You can't really say that in the deed. And if you're doing a ladybird deed, then you're probably not doing a trust. So you could say something maybe along those lines in the trust, but you can't say that language in a deed. 2, can you give a ballpark range for cost of creating a trust from a simplistic one to a complicated one? Sure. So for a single person, if we're just, I don't usually just do a trust. I usually do a trust and then a simple will. Like I said, that pour over will. I do a deed that deeds any of your properties into your trust. So if you have 1 property, it's cheaper than having 5 properties, obviously, because we have to do a deed for each property. And then I always recommend that you do a financial power of attorney and a medical power of attorney. So for a single person, you could be right around $1,000 up to about $1,500, depending on what how many assets you have, or if it's more complicated. For married couples, you're probably starting somewhere between maybe $1,300, $1,400, $1,500, somewhere in there, up into the 2,000 mark. Because if we have to do 2 trusts, or if we have to do more complicated trusts, or if we have a lot of properties that we need to deed. So it's not super expensive. I had a client yesterday tell me that she was single. Hers ended up being right around $1,100, $1,200. She was so afraid to talk to me about it because she heard from everybody that for her alone, her trust was going to be $2,500 to $2,800. And it just made me so upset because you charge for the time you put in. Nobody's putting in $2,800 of worth of time on a single lady who has a house and $20,000 in the bank. It's crazy. So just make sure that you're not, paying too much. Okay, next question. If there is not paperwork found, how do you find out if and where trusts are? That's a tricky one too, because trusts are private. A lot of times when people do wills, they will then record them with the probate court, so the court has track of them. But the great thing about doing a trust is it is private. So in our office, for instance, when we do any documents, we make 3 originals, and we give 2 originals to the client, and we keep 1 original on our file, and we also have a copy on our computer. I can't think of it. We have a copy too, just in case we need it. So if you know who the attorney is, they usually will have a copy of it. If you don't know who the attorney is, then it's going to be difficult. You just have to look through. I always tell my clients to make sure that you tell your person who's going to be in charge exactly where your documents are. Or, like I said, often I will give 2 originals. I always give 2 originals, and you can give one of the sets of the originals to the successor trustee. Or if there's a husband and wife and they want to keep them both, they can make photocopies of everything just to make sure that the person knows what they're going to be doing, and then make sure you tell them where it is. I wish there was a better answer to that. If probate is public record, are they viewable via internet? I don't know if the cases are online. I know that you can walk right into the court and ask to see the file, and they have to show it to you because it's public record. I really don't know the answer to that, but I can get that back to you. I don't think so. Some documents might be like opening and closing documents, but I don't know if all of the documents are on there. How do you find out if you were left anything if your father's second spouse cuts off communication and does not share any info? I'm so sorry. That happens a lot. If you know, I guess you could write a letter and ask for a copy of his, estate planning documents. If you don't hear back from them, then most likely they don't have anything, because state law says that if you are a beneficiary, they have to give you a copy of the trust or the document, and they have to tell you, what you're entitled to. So if they're not telling you anything, my guess is that maybe he's changed his estate planning to leave everything to her, which would be awful, and I'm sorry. And that's why we try to do these other things up front. Or you can maybe talk to any of his financial institutions to find out who the beneficiaries were on the accounts. So I just had this yesterday with a client that their Dad passed away. He, we talked about, we knew he was going to die. He talked about making sure he had his kids listed as beneficiaries on his credit union accounts. And he said, yep, I'm going to do that. And then they get to the credit union and they won't tell them anything. And I'm just like, oh, geez, that means that either he left it to somebody else or there's no beneficiary. So it's kind of hard to find out, one or the other. So they went to a different branch of the credit union, and the lady was like, nope, he didn't leave it to somebody else. There's just no beneficiary. And luckily she told them that, so that they knew they had to open probate. So sometimes you can go to the financial institution and ask them if you were a beneficiary. If you were a beneficiary, they will tell you. Or if it's a life insurance policy or a 401k or an IRA or a Roth or any of those things, and you think you may be beneficiary, if you contact them and you are listed as beneficiary, they will tell you. If they don't tell you, that means that either you're not listed as beneficiary or there is no beneficiary listed at all. Okay. Okay, let's see. What happens if you change your mind about things in your trust once created? Okay, that you can change it. So the great thing is that living trusts or revocable trusts are what most people do. The only reason you would do an irrevocable trust is if, trying to protect things for Medicaid or for creditors or things like that. But, by and large, we do regular living trusts, and they're revocable or revocable. So which means you can change them whenever you want to. You can change your powers of attorney. As long as you're competent, you can change anything you want. And it's not like you'd have to go through and pay everything that you had to pay the first time. It just might be a couple $100 here or there to make changes. This one is, my brother is on the deed to my parents' house, but my parents have it in their will to divide the house after the deaths to be divided amongst the surviving children. Can my brother keep all the money from selling it to himself without following the will? Yes, that's exactly what I'm talking about. So if your parents are still alive or one of them is still alive, either have your brother sign off and have them do a ladybird deed that gives it to all of you, or like I said, I don't really like having somebody on the deed. Maybe they could do a trust that gives it to all of you. That's Kimberly, I'm sorry, I probably shouldn't have said who you are, but that's exactly what I'm talking about. So we don't want that. Let's see, I'm missing some things there. So this one is, with more than one child, best to have co-executors of the will. Reason why I asked is my mom and dad passed and appointed my brother, one of 4 siblings, and he did not keep us informed of what is going on. And he took a car for himself that my mom said was supposed to be part of the assets and has kept us in the blind about the trust. So that's, usually I say, no, you shouldn't have more than one executor or personal representative, because if they don't agree, nothing gets done, But in a case like this, obviously, you have issues. So like I said earlier, he has to give you copies of the documents. He has to give you accountings. It's required by law. And if he's not doing that, you can go to court to have him removed. Or if he took the car, for instance, you can go to court to have him removed and have somebody else appointed because he's not acting in your best interest. His job is to protect the beneficiaries, which is you guys. So if he's not doing that, I would have him removed. And I would definitely, first of all, ask him for copies of the trust. I would ask him for, the only other thing I can think of is, like I said earlier, is that he's kept us in the blind about the trust. Well, maybe someone changed it and the trust says everything goes to him now. If that's the case, then he doesn't have to give you a copy of the trust. It only is if you're a beneficiary that you're entitled to a copy of the trust. Okay. I'm not going to answer that one because it wasn't for me. Okay. What if they have a co-signer on the account, like a second wife? So same deal. It depends on how they list it. A lot of times people think it's a co-signer so they can sign checks, but in actuality, at the bank or credit union, they have them listed as a co-owner. So you have to make sure that it's not a co-owner, so that if something happens to him, it just doesn't automatically go to the second wife if that's not what he wants. However, if she's a co-signer, she can write whatever check she wants, and he must trust her to do that, because if she wanted to take every dime out of that account, she could. So for instance, my mom is remarried and my stepdad is awesome, but my mom, she was pragmatic and she's just like, you know what, I want both you and Larry, my stepdad, as my powers of attorney, or either one acting alone, which means Larry lives with her. He can pay bills if he needs to for her, whatever. But I would have the authority to just look at the bank accounts and do everything that, peek into everything to make sure everything's happening on the up and up. So if he's doing something, taking assets of hers, I could, have him removed as the power of attorney, or get a conservatorship for her, and not have him be in charge anymore. Because, I guess we have differing interests, because I would be looking out for my sister and I, and he might be looking out for himself. Now I say that, and I'll tell you that that's not the case at all. Larry would give me the shirt off his back, but we don't know. We don't know exactly what's happening, and I always try to convince people that if they're even a tiny bit concerned, maybe have one of your kids with your new spouse on these documents. Is all pages of the trust document needed to have initials of grantor and trustee? No, they don't. For the will, we usually have people initial the corners of the will, because that is something that proves that the person read the will, because the state likes to see that. But for a trust, no, they don't have to be initialed. They just have to be signed at the end. Would it be better to add a beneficiary to your bank accounts rather than adding them to the account itself? Yes, it would be better. And once again, if you have more than one child, maybe add all 3 of them or 2 of them as beneficiaries, so it's done equally. The only issue with that is, let's say you own a home and you did a ladybird deed and you're leaving the house to the 3 kids, okay? And then you have a big bank account, maybe $50,000, $60,000 in that bank account, and you're leaving that to your 3 kids. But there's one kid that really does everything, and they go into the bank and they get their third. Everybody grabs their third out of the account, and that kid pays the bills on the house until the house sells. Quite often, that kid ends up with less, the responsible one, because their siblings don't pony up any money to help pay these bills, or pay, for the funeral, or pay for this, or pay for that, and they might end up with less money in the long run. So sometimes doing the trust is better, because then everything is paid off the top before anybody gets anything. Scenario: trust agreement for John Smith, revocable trust. John died in 2016. His son and their family are living in the home, continuing to make the mortgage payments to the bank. There are 2 co-trustees. John died and the other removed himself from the trust. The successor trustee is the son living in the home with his family. The question is, how do we resolve the trust in order to have the home put into our names to remortgage the home and take advantage of a lower interest rate? I see what you're saying. How do I sign off the trust or the deed? So if the trust says, if it's an only child, that's easy. If everything's going to this only child, then there's something called the trustee's deed that the successor trustee can write, and it basically says, I, son, as trustee, deed it to myself, son, as beneficiary, and it gets it into your name, and then you can refinance. If there's more than one child and it doesn't specify in the trust that you get the house, then we have to make sure that everything's balanced out. Otherwise, we don't want somebody coming back against you. But basically, just the simple answer is, it's called a trustee's deed, and you deed it out of the trust into your name. So that's pretty easy. The next question is, but the beneficiary would only be able to access the account once the death certificate is presented to the bank, not before. I know this because I looked into this while my dad, after my mom passed away, and he went and got that power of attorney so I can access his account in the event he is unable to do so for any reason. Correct. So if that's the whole point, if you get a good power of attorney and you're not on the bank account, the power of attorney will let you sign checks and access the account, like I talked about earlier. And then after he's gone, then it would just go to you and you would own it as beneficiary. But while he's alive, you need a good power of attorney that would allow you to handle things for him if he needed help. That's exactly right. Can you refer a good elderly law firm? Of course, I want to refer myself. So you can get, I think the next slide, or maybe I don't have a slide that has thought I did, that has my contact information, but I know Lisa can get it to you. So I do it. There's other firms that do it locally. Once again, you can talk to any nursing home in the area that you're looking at, and they can help you. You'll see the ones on TV. I can just throw that out there. And I will tell you, I'm going to give you an honest, true story. About 3 weeks ago, I had a client come in because his brother told me to come see him because I'd helped his brother with his in-laws. And they said, So he said, my mom is in the nursing home up, and I live up in the Holland area, and there's an attorney up here that he's on TV, and he's going to apply for Medicaid for my mom, but we have to spend down, she has about $32,000, so we have to spend down $30,000. So his attorney fee to get my mom on Medicaid is $30,000. And he actually showed me the contract, and I could not believe it. So be real careful. There's reasons that people can afford commercials, TV commercials. They take advantage. But once again, talk to the nursing homes in the area that you are. If you're asking for somewhere else in Michigan and you're not quite sure and you want to call my office and ask us, we have names of other attorneys in different counties that we highly recommend. So you can call my office and ask about that too. There are 3 people in a trust agreement and 2 would like to sign off. They don't want anything to do with it. How do they get removed? And after they are, how does the sole person take ownership? So I'm not sure if it's, okay, so they must be the beneficiaries. So what would happen is they would have to waive their interest in the assets, or they would have to get the assets and then just give them over to the other person. So that actually might be the easier way to do it. But if the person, I just don't know if what you're telling me is that somebody has passed away and these are beneficiaries, or if they all 3 own something together and the other 2 just don't want it anymore. If they're the ones that created the trust, they just amend the trust and says, you know, everything is this other person's, I don't want it anymore. But if they were beneficiaries of it, we can't amend the trust now because the person passed away and they can't amend it after they've passed away. So what usually happens is we just deed it out to, if it's a piece of property, for instance, we deed it out to all 3 of them, and then the other 2 just sign off on it and give it to the other person. There's ways to do it like that. So I hope that helps. I can vouch for Stacey. She is an awesome elderly law attorney. Oh, thank you. Okay. I think that's my last question, unless you guys have more. Don't see any more, but these were really good questions. And I can hang out. I see somebody else typing that I know. Okay.
I think someone's typing something else now, Stacey, but
yeah.
Thank you so much. This was so informative, and we really appreciate your time and energy to put this together for us today and answer so many questions. I do think we have a couple more people asking
they're coming. They're coming.
So yeah.
Minutes,
so,
yeah,
okay.
we've got time.
Right.
Yeah. So let me see. Okay.
Thank you.
Ladybird deed, how long does this need to be set up for needing state assistance? So you don't have to do that 5 years in advance. So let's say that someone's in the nursing home on Medicaid already. We can do the Ladybird deed then. It's okay. You don't have to do that 5 years in advance. Someone says, thank you, Stacey, which is, you're welcome, which is nice. Thank you, Stacey, for your help yesterday. Oh, you're welcome. I would completely recommend Stacey also. Great knowledge and help. You're very, very welcome. Okay, we got more people. We got more people typing. If you still own your home, can you put it in your trust? Yes. Oh, still owe on your home. Sorry. If you still owe on your home, yes, you can still put it in your trust. So what happens, just so you know, it depends on the bank. So let's say you put your house in, you owe on your house. You have a $200,000 house. You owe $100,000. We put it in the trust, and then down the road you want to refinance for a better interest rate. Some banks will let you do it if it's owned by the trust, but most of them are going to say, no. You got to put it back into your name to refinance and then put it back into the trust. And that's kind of a hassle, but if you're going to save a ton of money on your interest, then it's worth spending a couple $100 to take the house out of the trust and put it back in the trust on deeds. But yes, you can put your house in the trust even if you still owe on it. Do you have a suggestion for a firm in Berry County? Well, we do Berry County because it's very close. And to be honest, my paralegal lives in Berry County. And so we're up there all the time. So, you know, I don't come on here to promote myself, really. I come on here to give you good advice. But if you have questions, feel free to give me a call. And if you want somebody else in Berry County, we can give you some names when you call. If one puts an asset farm in a trust and then sells it, do the funds stay in the trust and other considerations? Yes. So if the house is in the trust and then the house is sold, and then, or the farm is sold, the assets from the farm go into the trust. But if it's a living trust, you can use those assets for whatever you want. You can go buy something else or whatever. If you are a beneficiary of that trust and you're the trustee and you sell the farm, and then the assets go back into the trust to be distributed amongst the beneficiaries, you can of course pay for any expenses off the top from the money from that farm before you split it up with the other beneficiaries. Hope that answers that question. Still got more coming, so I'm waiting. Okay. If you called in and would like to be sure that you don't miss upcoming MW, oh, that's Helen. That's Kate, sorry. All right, I'm gonna skip Kate. Can you put your contact details in here in the comments? Yeah, I can. I'm so sorry about that. I really thought they were on my last slide, but I don't think they are. Yeah, there's no more slide. I thought we did that. Do you have any recommendations for attorneys in Southern California? You know, I might. I have to do some digging, so please feel free to call my office, and I will give you the contact information. Let me put it right now. I'll do it right now. There it is.
And Stacey, we'll also have it on our link on if anybody needs it and wants to reach out to MWR Battle Creek at DELA.mil. We'll have Stacey's contact information if you don't catch it on here as well, and also a recording of today's presentation. If anyone wants to hear it again or have their spouse or someone else listen to it, it will be recorded and uploaded on the MWR site.
Thank you. And I know Lisa told me to put that last slide on there. I don't know how I missed it, so I apologize. My handout that I usually give out has it on the last page, but I missed that. Okay, how do we resolve the trust that has been since the person revocable trust died in 2016? The others don't have interest and we would like just to take over the mortgage payments in our name if there are beneficiaries. So I'm not quite sure. Okay, how do we resolve the trust that has been since the person died in 2016? The others don't have interest and we would just like to take. So what I would do is deed it out to all three of you and then have them deed off to you, and then it's in your name. Once again, it's a trustee's deed. So whoever the trustee is can deed it out to either all three of you and then it goes to you, or we have them sign waivers that say they don't want it and then it can go to you. But most likely I would, because it could end up going to their kids, and I don't want that. It just depends on how the deed is written or how the trust is written. You have to look at the trust, but the easiest way is the trustee does a trustee's deed to deed it out to the three people, and then the other two people deed it over to you, and then it's in your name, and you can get the mortgage in your name and or whatever you need to do. You're welcome. Someone said thanks, and you're welcome. Great job.
Stacey, I had someone else ask a question on a different format. Can you ask Stacey about transferring 401k TSP into a trust? Is it a good idea or a bad one?
It's a bad one. That's a great question. So let me tell you why. If you're, I'll talk about us. My husband has, 403B because he's a teacher and a coach at Lakeview. His 403B has me listed as the primary beneficiary, but our trust listed as the contingent beneficiary because my children are minors. What happens is if the trust was the primary beneficiary, okay, and Kyle passed away, then the trust gets the asset, but it has to take it all in one lump sum and pay all the income tax off the top. So you could be losing up to 30 to 40% of your asset. If your spouse inherits it, they can take it and roll it into their own inherited IRA and take out required minimum distributions over their lifetime. If your kids inherit it, if they're old enough to get it, they have 10 years to get it out and take out a tenth every year and not have to pay all the income tax off the top just when they take it out. So there are tax implications to not having your trust as the beneficiary, or of having your trust as the beneficiary of your 401k. So the only reason that you would ever do it is if you have minor children like mine. And I'll tell you, you guys have probably heard me talk about my kids before. I'm not sure I'm going to trust them at 18 to be able to handle a 401k either. So we would probably still keep it in the trust until we thought they were old enough to be able to handle it. And then at that time, we would change the contingent beneficiary to them. They're going to lose a lot of money in taxes if something happened to both of us before they're old enough. but it's better than them just blowing it and not being able to handle it when they turn 18. And as minors, they can't own an IRA anyway. So that's just kind of how it goes. Thank you, very insightful. You're welcome. All right. If we get the mortgage in our name, will our property taxes go up, or is it a quitclaim deed deal? So as a beneficiary, you'll get it. And then if your siblings, okay, I'm going to do a caveat here. I am not an accountant. I am not a CPA, and I'm not a tax attorney. But this is what I understand, and I could be wrong, so I would double check this with your accountant. But 2 years ago or 3 years ago, there was a change in the law that says you can deed to first degree relatives without uncapping the property taxes. So and then when you inherit something from a trust, it doesn't uncap. It's only when you go to sell it that you would have to pay, possibly capital gains on it. But it's only if you get it into your name a different way. So if your siblings deed it over to you, it shouldn't uncap the property taxes. That's what I understand, but I really want you to double check that because once again, I am not a CPA. Where do we get waivers? Not quite sure what that is.
Stacey, I'm going to stop you here because we went over our hour
Okay.
now. So if anyone has any more questions, I just suggest that you give Stacey's office a call, and they can certainly help you or give you more resources of what you needed. But we so appreciate you at DLA, and really an informative presentation that you did today. So thank you so much, Stacey, and thank you everyone for joining us.
You're welcome. Thank you guys. Have a great weekend.